Order! Order! You are an incorrigible delinquent at times. Behave yourself, man!
So, the High Court has ruled that it's Parliament's prerogative to give the green light to negotiating our exit from the European Union. The British people voted to leave the EU in June, on June the 23rd, but the High Court says the process to achieve that cannot be determined by government alone. Parliament is sovereign, say the judges, and its approval is a constitutional necessity. Joko has all the details.
At stake in this case was whether the government could trigger Article 50 and so formally begin the process of the UK leaving the EU without a vote in Parliament. The government maintained it could use the royal prerogative to make and withdraw from treaties. But those challenging it, led by investment manager Gina Miller, said triggering Article 50 would remove rights enshrined in the 1972 European Communities Act, and therefore MPs should have a say. Lord Pannick, acting for Gina Miller, said Parliament, having to accept its authority being undermined, was not it straining at a gnat, but swallowing a camel. The government's QC said it was very likely Parliament would be asked to approve the final settlement, but those bringing the case were trying to invalidate the decision to leave the EU. This morning, the High Court ruled that the government does not have the power to trigger Article 50 using royal prerogative. The government have said they'll appeal the decision in the Supreme Court. And this is what Gina Miller, who led the case against the government, had to say earlier this morning.
This case was about process, not politics. My dedicated team at Mishcon and Council and I are absolutely delighted that we've been able to be part of this debate and to bring some sobriety as we go forward. The judgment, I hope, when it's read by the government and they contemplate the full judgment, that they will make the wise decision of not appealing, but pressing forwards and having a proper debate in our sovereign parliament, our mother of all parliaments that we are so admired for around the world. Thank you.
Gina Miller there. And this is what the International Trade Secretary, Liam Fox, had to say about the ruling in the Commons this morning.
Mr. Speaker, the government is disappointed by the court's judgment. The country voted to leave the European Union in a referendum approved by Act of Parliament. The government is determined to respect the result of the referendum. This judgment raises important and complex matters of law, and it's right that we consider it carefully before deciding how to proceed.
Liam Fox in the Commons. Well, let's speak to our political editor, Laura Kunsberg. This is a big moment, a very big moment in terms of the process of UK leaving the EU. The executive government has been overruled.
Yes, it's an absolutely huge obstacle now for Theresa May, a real headache for the government. They've said in the last few minutes that they are determined to appeal. They are going to take this straight to the Supreme Court. But it is a huge problem, and it is absolutely not initially what the government had been expecting. Now, believe it or not, it centres on a point of law that goes back to 1610, where essentially the king, it was King James VI and first, was told that he could basically not just do what he wanted. The king hath no power by his proclamation. This morning, Theresa May has been told that she has no power by her proclamation. She does not, as Prime Minister, according to the High Court, have the power to get on with leaving the EU without consulting Parliament first. And that is absolutely what she wanted to do. Frankly, she wanted to just be able to decide her terms and conditions of the negotiations, to get on with it, to deal with Brussels, basically on her own with her government ministers. MPs absolutely have shown that that's not what they want, but this ruling emboldens Parliament, it emboldens MPs, and unless the Supreme Court overturns this ruling in December, which may well happen, it's really unclear what happens next. The Commons will, of course, try to flex every single muscle available to them to have as much scrutiny of the government's negotiating plans as possible. But there's a real question mark, Joe, in terms of what happens next and how the government will actually respond to this if the Supreme Court does not overturn the judgment.
If it isn't overturned and therefore Theresa May and the government has to consult Parliament before Article 50 is triggered. What does that mean practically? You say the Commons will flex its muscles. I mean, it could just be, I presume, a vote to trigger Article 50, or will they insist that there is a wide-ranging debate on the negotiating stance and the position of the government?
Frankly, at the moment, it is just not clear. It could be a very narrow vote. And of course, the government, some people might suggest, could actually do the smart thing and do that now as soon as possible, just actually accept they'll have to have some kind of vote, but keep it as narrow and as tight as possible. But MPs, of course, could try to amend even a narrow bill. They could try to stick down all sorts of terms and conditions in order to, for example, have the debate about the single market, or to have the debate about what an immigration system should look like once we're outside the European Union. And really, this is a blank sheet of paper at the moment, because of course there's absolutely no precedent for this whatsoever. So Theresa May's problem is, even if she tries to stick to a narrow vote, MPs will try to do everything they can to give themselves as much power as they can. But we just don't know at the moment if it will be a narrow vote or something that is a much bigger piece of legislation that would have to go through the Commons and then have to go through the Lords. And of course, the big risk then is that it could push back the timetable that Theresa May wants to stick to of triggering Article 50 by the end of March. And the implication, just finally, of all of this is if Parliament is going to be a total headache and create all sorts of problems for Theresa May on this, will she finally give in to the temptation of calling an early election? Because, of course, if she had a thumping majority, well, this headache would pretty much go away.
Indeed, and that's what's being debated at this very moment. Laura, thank you very much. And I presume, Andrew, the Supreme Court would hear, they've already dated, haven't they?
I think
Given
December
2 days.
the 7th is the date
beginning
the
of December.
Supreme Court will meet. While you were talking to Laura there, we had the Bank of England is keeping interest rates at 0.25%. It cut interest rates earlier in the summer after Brexit. There was talk there may be a further cut. Indeed, the governor indicated there might be, but there hasn't been. They stay at 0.25%. Now, we're joined back on the Brexit issue by the Labour MP, Stephen Kinnock. He was a Remain campaigner. Conservative MP, former Justice Minister Dominic Raab, a Leave campaigner. Dominic Raab, if the Supreme Court upholds this, how big a setback is this for the government?
Well, I think there's a pretty good chance that the Supreme Court will either overturn it or narrow the focus, because as Laura's just said, and she's absolutely right, this has spread uncertainty when what I think most people wanted was a bit of clarity. And the reason it's uncertain is the court has effectively said government can't do this alone, but it hasn't said what Parliament must do. So what would the vote be on? What's the content enough to satisfy the judges? Does it have to go through the unelected Lords as well as the Commons? So I do think that it has shed a huge amount of uncertainty, but the bigger political question is outside the Westminster Village. A lot of people, 33 million people, participated in this referendum. It's quite extraordinary that a fund manager can go into the cloistered High Court with lawyers self-funding and overturn the will and the verdict of the British people, if that's in the end where this ends up. I'm actually not quite that pessimistic. I think we'll get this through. I don't think it's going to derail Brexit, but I think it's probably the high watermark for the die-hard Remainers, because they're pitting themselves against the clear, if close, verdict to the British people.
Stephen Kinnock, if the government put a motion before the Commons to trigger Article 50, how would you vote?
I would vote in favour of triggering Article 50. But I want to make it clear that what this is about is bringing the terms of the negotiations to Parliament to do that, so that Parliament can do its job. Which
so,
is
just to clarify, would you, before you very clearly said there you would vote in favour of Article 50, but to do so, would you want to see a broad outline of the negotiating position before you did?
Precisely.
And if you didn't, how would you vote?
The government has to bring a negotiating position that will deliver a sane and balanced Brexit.
Well, it doesn't have to. I mean, you think it should, but it doesn't have to.
Well, this is my position.
Yeah,
this
understand.
would be my advice to Theresa May.
I understand.
I'm not sure she'll be listening to it, but I'm sure she's tuned in.
But just to clarify, because I think there is now a condition on what you said. If the government doesn't at least give an outline of a strategic vision for its negotiating strategy, you might not vote for Article 50.
We have to act in the national interest, and if we can see that the negotiating position the government brings is clearly not in the national interest, we can't vote for it. If the government brings a vote which is simply, do you want to trigger Article 50, yes or no, with no detail whatsoever, I think that would be a betrayal of our democracy.
And you wouldn't vote for that?
I would vote in favour of triggering Article 50 if that's the only question that is on the table. But the spirit of this ruling is that Parliament is sovereign, that Parliament has to be able to to scrutinise and hold to account the government. That is how our democracy works,
That's actually not
and
what the
that
High Court
has
said
to
at
be the spirit of it, as I see
you read
it,
the
is that
judgment,
Parliament. Yes,
Stephen?
I have. Yes, I have.
Because it doesn't say that at all.
Well, it says very clearly that Parliament is sovereign in this case. Government is not sovereign.
All right.
In order for a Parliament to exercise its sovereignty, it has to scrutinise the negotiating position. We voted for leaving the EU, but there is no clarity on the type of Brexit we're going to
I'll come
have.
back to that
That's
in a
what
minute.
Parliament has to debate.
What's he saying that's wrong in your view?
Well, there's three different positions on which way he'd vote, and that's the problem. If we're saying that Parliament should have a vote simply to establish that Parliament has the right to do it, we can have the vote this afternoon on triggering Article 50. It sounds like Stephen would vote for that. On the other hand, if what Stephen is really saying, if I don't like the terms of what the government is trying to achieve, I might vote against it, then what you're allowing is die-hard Remainers to try and frustrate the referendum decision. And actually, this is right. Let's remember, viewers will be sort of perplexed about this. This is before the negotiations have even started. And the government has made quite clear that there will be scrutiny right the way throughout. There's a debate today in Parliament on financial services. I sit on the Brexit Select Committee. We met yesterday. There's clearly going to be a debate and a vote on the end package. But do you really allow Parliament a veto before we even begin? And reading between the lines, that's effectively what Stephen is advocating.
Well, there's
No. What I'm
You said you might vote
advocating-
against if you don't like the terms of the negotiating position.
If I could just
Let's
answer
hear.
the question. What I am advocating is that it's clear to me that the government needs to bring its going-in position, the broad principles of its negotiating position, to Parliament. Anything else would be a betrayal of our democracy. This is the biggest decision we've taken since the Second World War. All of the Brexiteers campaigned on the basis of the sovereignty of the British Parliament. We must surely be trusted by the government to have a sober and sane debate about the type of Brexit that we're going to do.
let me ask-
Nobody
Nobody
voted on the 23rd of June to make this country poorer or to not listen
But
to
now you're just
the
in
democratic...
rhetoric. I don't want
Yeah.
to try and pin you down on this.
That's the job of
If-
Parliament,
if-
to ensure
if-
that doesn't happen.
if
Act
the
in the
government-
national interest.
If the government brings forward essentially legislation now to enshrine its negotiating position, and the Commons Parliament would then have the ability to vote on each clause. It could try to amend it. It could try to water down a commitment to leave the single market or the customs union. It would become one massive negotiation between the Commons and the government, in which the government would day by day be showing its hand to the European Union. Why would that be in Britain's interest?
The government's job is to bring a position to Parliament that commands a majority. And when it secures that majority, Theresa May has a far stronger mandate in the negotiations that she's going to have with the rest of the EU. I think we have to see this as being beyond party politics. The whole referendum cut
was
across
beyond
all of that.
party
Exactly.
politics.
This is about the national interest.
But there's a suspicion-
Leadership is about reuniting the country
there's a
after a
suspicion-
deeply divisive referendum. You
But
don't
you-
reunite the country by ignoring Parliament.
Well, you may not reignite the country, though, by trying to thwart the will of the people either, as exemplified in June the 23rd. And there is a sense that, maybe not you personally, but a number of people on your side are just looking for every chance to try and unstitch the decision that was taken on the 23rd.
I don't know where you get that sense from. I haven't spoken to a single
speaking
Labour
to
MP.
politicians.
I haven't spoken to a single Labour MP who isn't saying that the will of the people, as expressed on the 23rd of June, must be respected, and that was to leave the European Union. But what we need to clarify is what sort of Brexit are we going to
But
deliver?
Stephen, you don't want clarity. You want a right to veto the negotiating position. Reading between, I mean, not even reading between the lines. You said that very clearly. There's this huge difference, this gulf between scrutiny, which we all agree on. I'm on the Brexit committee. I'm going to be scrutinising the government very carefully on all of the aspects, and a veto. And what it sounds like is you want a veto. Now, you may exercise that responsibly, others may not. But I think that the British people, having voted on a turnout of 72%, will find that extraordinary.
But what would be wrong?
It's a vote, not a veto.
What would be wrong of having a national debate in our national debating chamber called the Commons, which played its part in constructing the broad outlines of our negotiating position for what is, an enormous, historic step forward? What's wrong with doing that?
So first of all, given what the High Court has said today, it won't just be the Commons. It hasn't just been confined to the Commons. It'll be the unelected Lords. So I think that's a democratic problem.
The Lords have said they won't block anything. They will scrutinise, they will debate.
Who speaks for all the Lords? Let's see.
But let's stick for the Commons.
Well, I know, but I wanted to make the point about that, because that's a democratic point. Secondly, Of course we want scrutiny. There have been several debates already. Parliament today is debating the impact of Brexit on financial services. The Brexit Committee will be holding the government's feet to the fire. This is not about scrutiny or shaping the argument.
You can't scrutinise something that you don't know the shape of.
Well,
and we don't know the shape of the government's
if you're
negotiating
right, you
position.
can't veto a negotiating position in advance. Because
no, but they want the government to come forward with the negotiating position. Now, what would happen if the Commons voted against that negotiating position?
So I think that's the Pandora's box. I mean, ultimately...
Well, Pandora's involved in this as well. I mean, everyone is having a say.
Yeah,
Just
but
what would
no one
happen?
voted for Pandora.
Would that lead to an election?
Well, I think the elephant in the room here is if...
So there's an elephant in the room
If
too.
we get to the stage where effectively Stephen and his colleagues are not willing to allow this negotiation to even begin, I think there must be an increased chance that we will need to go to the country again. I think that would be a mistake, and I don't think those trying to frustrate the verdict in the referendum will be rewarded.
And isn't that Labour's worst nightmare? That there is a huge argument in the Commons over the shape of our negotiating position. The Commons tries to water it down because we know there's a majority for Remain in the Commons, and an even bigger one in the Lords. So the government's negotiating position is watered down, and in the end the Prime Minister says, I've had enough of this. This is not what the British people voted for. The Commons is interfering with that. Let's go to the country and have an election to determine that. And Labour gets wiped out, not just in the south, but in the north, which voted to leave.
Just focusing on the actual question of the renegotiation.
No, just focus on the question I asked you.
Sorry, there was a pre-referendum majority for Remain in the House of Commons. There is now a post-referendum clear majority for Leave, and that's the critical point. I don't know what Dominic and the Prime Minister and all of these people are scared of.
Well,
why don't we just have a mature, sober debate in Parliament, as we do on any issue that comes before us, and this happens to be the most important since the Second World War. Let's have the debate, let's move forward. In terms of an election, bring it on.
Melanie, you've been listening carefully, taking notes indeed as well. As I think it's only all of our viewers take notes when they see the Daily Politics too. It's only fair and right. What's your take?
Well, it's a mess. This is a constitutional crisis which has been lurking ever since the Brexit vote. It is the will of Parliament versus the will of the people. Once you have a referendum which sovereign Parliament has given the people, then you've got a problem, because if there's a conflict, who wins? In my view, the idea that Parliament is involved in negotiation is so against the national interest. There is no treaty where a government will sensibly allow Parliament to dictate the terms of its negotiation, to show its hand. Mrs May has to be absolutely circumspect. I think she's been entirely correct not to show her hand at all. So in practical terms, I think that would be quite wrong. A general election, I'm not a lawyer, I'm not a constitutional expert, but in terms of what the law, of what the High Court has actually said, I'm not even sure that a general election would solve this. What the High Court has said is that Parliament is sovereign, and that Parliament, if the executive, if the government triggers Article 50, then that will deprive the British people, through Parliament, of exercising their rights under the European Communities Act to challenge certain things and do certain things. Now, a general election will simply give, for example, Mrs May, if she were to win an election, she would go into an election hypothetically saying, I am going to trigger Article 50. Everyone says yes, hypothetically.
You get a mandate.
Parliament is still sovereign. Parliament still has to have the final say. And the problem would still remain, according to this court judgment.
Well, except that
if
you were
Article
more likely
50
to get a
binds
bunch
Parliament,
of MPs who agreed with Mrs May's position rather than even Stephen Kinnock's position. That would be the case for it. She would have a bigger majority, and she would, during an election campaign, she would have to explain broadly her negotiating position.
My point is that the constitutional point still remains. My final point is this. As I say, I'm not a lawyer, and I've only read the summary of this judgment. But as far as I can understand it, what it's saying is that the problem with triggering Article 50 is that once it's triggered, Britain leaves, and once Britain leaves, then the rights conferred on the British people under the European Communities Act passed by Parliament as part of our membership of the European Union, those fall away. We no longer have those rights. Now, some of those rights relate to domestic law, and it's within the rights of Parliament, therefore, to pass laws which give us those rights even so. The rights we would lose automatically, as I understand it, are the rights pertaining to European Union laws and institutions. In common sense, leave the law aside for a moment, in common sense, if the British people have voted through a referendum and decided to leave the European Union, why should anyone in common sense be concerned that they are losing their rights to continue to use the institutions of the European Union?
Because Parliament is saying that just as Parliament conferred these rights in the 1972 Act, the judges say that only Parliament, under our Constitution, can take these rights away or amend them.
That is the legal position, but I'm saying in common sense...
That's a constitutional position.
Well, in common sense, it's absurd.
All
because the rights that we are going to be losing, which we are considered to be, which the court is saying we shouldn't lose, are the rights to use European Union laws and institutions.
All right. Well, absurd it may be, but we've also run out of time. Thank you both.
Thank you.
Now let's go back to our main story. The news that the High Court has ruled that Parliament, not the government, should have the right to trigger Article 50. Here's what former Cabinet Minister and Leave campaigner Ian Duncan-Smith had to say earlier.
I mean, the key thing about this is that, you know, at the end of it all, there was an Act of Parliament. That Act of Parliament gave the British people very explicitly the right to make the decision whether we stayed or left. That decision was made on June the 23rd, and they voted to leave the European Union. Now, the problem is that if you then go and ask the government, and Article 50, by the way, sorry, triggering Article 50, by the way, is the only way by which the government may do this. So that means that what these people are doing is trying to say they should go to Parliament and lay out all of their negotiations, and then Parliament can vote on that. And that's a recipe for complete chaos.
Well, I'm joined by the chairman of the Brexit Committee, the Labour MP, Hilary Benn. Welcome to the Daily Politics.
Hello,
Is that what you are and you and your colleagues are going to do, lead to chaos in the Commons, if MPs have the ability to debate the negotiating stance and the opening position of the government in these negotiations?
Well, obviously, the Select Committee I have the honour to chair has not yet had a chance to consider this judgment because it only happened this morning. But we have decided in our meeting yesterday we're going to launch an inquiry into what should be the UK's negotiating objectives. I think the thing to say about the judgment today, it's an important judgment about the sovereignty of Parliament. It is not about a decision on whether we're leaving the European Union, because we are, because the British people made that choice in the referendum, and I think Parliament should uphold it. But there is, as your question rightly asked, a debate to be had about what kind of relationship we're going to have, and therefore the government's negotiating objectives are really important.
Right. In other words, you could frustrate the will of the people if there are endless arguments about whether the UK should leave the single market and or the customs union, which in effect, for people like Ian Duncan-Smith and Melanie here, would in a way reverse that decision.
No, it's not. It's not about reversing the decision. I think it's really important.
Is it about discussing whether or not we would leave the single market?
I think we need to separate out a decision on Article 50, because the British people have spoken, and the court has said, pending the appeal, that Parliament should take the decision about triggering that. I think we should uphold the referendum decision, even though I campaigned very hard against a leave outcome. Over here is a perfectly legitimate task for Parliament, which is to ask of the government, OK, so what is your plan? What are your negotiating objectives? We've seen in the last week or two, Joe, with Nissan, the government having said, well, we're not going to give you a running commentary on anything, because Nissan had said we're not going to invest any more unless we get some assurances. Some assurances were offered, and Nissan then announced a very welcome announcement that they're going to build their 2 new models in the UK. Well, that was an indication of what the government was going to seek in these negotiations. And if it can do it for one sector, then I think it's reasonable for society, industry, all the other people who are affected to say, well, tell us what your negotiating objectives are, not the detail of your negotiating tactics, your red lines, but what are you seeking to achieve here? Because Parliament, I think, legitimately would want to have a say on that.
As it stands now, and Andrew put this question to Stephen Kinnock, if there were a vote on triggering Article 50 tomorrow, would you vote in favour of that?
I would, because I said to you earlier, I think we have an obligation to uphold the decision of the British people, and they decided we're leaving the European Union. Joe, the only way you could do that is to start by pressing the button, but that is separate from what we should be seeking to negotiate
Except
in that process.
The Shadow International Trade Secretary, Barry Gardner, has said Labour will not commit to the mechanism to triggering Article 50 until I see the whites of ministers' eyes. That sounds like a threat.
Well, I'm not quite sure what he was referring to in making that comment, but I think it is very important in this process that we can't get into a situation where it would appear that Parliament was going to say to the British people, OK, you've had your say, but we're going to reach a different conclusion.
All right, well, let me put it to you then. If the government did come forward with an opening negotiating stance, one that you didn't quite sign up to, let's say it stated the UK will leave the single market, would you still vote in favour of Article 50 being triggered?
Well, I think they should be separated. That's the point I'm trying to make.
Well, hang on, what do you mean separated? I mean, if they come forward, which is what they could well do, if they have to pass an Act of Parliament, they have to pass legislation, and that's their opening position, how would you vote?
Well, that's much more complicated if it's going to be legislation. I don't think I mean, personally, I don't think that's sensible unless it becomes necessary. I would keep the two things separate, because one is the formal starting of a process that is necessary to give effect to the decision the British people have made. Separately, it's entirely legitimate for Parliament to say, once the government does come forward with its objectives, either, well, that looks fine, or that isn't quite fine, could you go away and
vote against
come
it?
back with something better?
Does that look like a veto to you?
I'm sorry, I just think I'm trying to follow what you're saying, but it seems to me like you're trying to have your cake and eat it.
No.
On the one hand, you're saying, the people have spoken, that must be respected. We cannot possibly go back on Brexit because we're going to go out of the European Union because people have spoken. On the other hand, we want to see the government's negotiating position. In practical terms, that will derail the process of getting out of the European Union. So on the one hand, you can be white on the white and say we couldn't possibly gainsay the spoken desires of the British people as expressed in the referendum. On the other hand, you're taking a position which would derail it. This is dishonest.
Right.
If you want to derail it, say so.
I'm afraid we're going to have to end it there. On This Is Dishonest.
Well, it certainly isn't dishonest. I think it's right and proper for Parliament to have a say.
All right, Hilary Benn, thank
Thank you.
It is a landmark ruling and one that has huge constitutional implications. Judges at the High Court have said that ministers cannot begin the process of leaving the European Union on their own. They have to get the approval of Parliament first. It follows a legal challenge by campaigners who argued that Parliament should not be sidelined. The government says it's disappointed by the ruling and it plans to appeal to the Supreme Court. This report from our political editor, Laura Koonsberg.
Decision time. Waiting for the moment. Would the law take on the Prime Minister? In a case brought to the High Court by a businesswoman, yes, it certainly did.
The result today is about all of us. It's not about me or my team. It's about our United Kingdom and all our futures.
Some of the most senior judges in the land ruled that the government must give MPs a say before the legal process of leaving the EU, known as Article 50, can begin.
This is a victory for parliamentary democracy over what might be regarded as a rather feudal notion of royal prerogative.
I mean, it took 3 of the highest court or judges in the land to come up with their decision, and I think it was a no-brainer.
The High Court was careful to say it was only dealing with a pure question of law. Nothing we say has any bearing on the merits or demerits of withdrawal from the EU. But the Secretary of State does not have power under the Crown's prerogative to give notice pursuant to Article 50 for the UK to withdraw. In other words, ministers cannot start to take us out without MPs' support. Even those bringing the case thought this result was unlikely.
Now I would ask them to do the responsible, sober thing, which is to do the job we pay them for, to debate all the aspects to do with leaving, and then have a vote.
And when you began this, did you think that you would win? Do you think this would happen?
In my heart of hearts, probably not. But as we went along, because we stuck to the black letter of the law, this was not about politics, it was about process. And my legal team and counsel were superb in the case they put together. So I became more and more confident that we would win and we would start this process that the government then will take on.
There were immediate accusations that wealthy self-interest was behind the case, and it's just an attempt to slam the brakes on Brexit. The faded grandeur of courtroom number 4 here at the Royal Courts of Justice doesn't always get this much attention, but today it does. These judges' verdict creates a huge problem for the government, a massive obstacle for Theresa May. At the same moment, ministers had to respond to the courtroom drama. They'd resisted attempts for the Commons to have a say before the legal process begins.
Mr. Speaker, the government is disappointed by the court's judgment. The country voted to leave the European Union in a referendum approved by Act of Parliament. The government is determined to respect the result of the referendum.
The decision now crosses Parliament Square. The government will appeal at the Supreme Court. But if those judges agree with today's ruling, the government will publish some form of new law for MPs to vote on, and the more troublesome House of Lords.
Well, the judges have laid out what we can't do, not exactly what we can do, but we're presuming it requires an Act of Parliament, therefore both Commons and Lords.
But here's the danger for Theresa May. Once the proposals are in Parliament, MPs might push to set the terms of her negotiation.
Parliament is going to have to take a decision when the government finally comes up with what its bottom line is on Article 50 clauses.
For a handful of Tories and all the opposition parties, especially from parts of the UK that didn't back Brexit, this presents a huge chance to cause trouble. Big trouble.
Scotland voted to remain in the EU, and my job is therefore to protect our place in Europe and in the single market as far as I possibly can. SNP MPs in the House of Commons will certainly not vote for anything that undermines the will or the interests of the Scottish people.
Parliament must decide. Absolutely not. We have a parliamentary democracy. People's will.
Real judges will make their next decision in December. And whatever they say, when it comes to leaving the EU, Parliament's braver from today. However you voted, the referendum was never going to be just down to you. Laura Kunsberg, BBC News at the High Court.
Our legal affairs correspondent Clive Coleman is at the High Court for us. Clive, I want us to just step back a bit. Just how significant was today's ruling?
Well, George, this was an absolute legal hammer blow delivered by the judges here. It was really a case, the constitutional case, of such great importance. It effectively defined the limits of executive, of government power. The government wanted to use these prerogative powers. These are old, ancient powers. They derive from the King and the Queen to trigger Article 50. The court here reaffirmed a fundamental principle of our Constitution, which is that Parliament is sovereign. Parliament can create laws, and only Parliament can take away laws and rights. And what we saw today really was an example of perhaps the constitutional clash of our times between a mighty government that likes to stomp around the Constitution, getting its way on the one hand, and independent judges who some might describe as unaccountable, unelected judges on the other, but who through the mechanism of judicial review can stop ministers in their tracks if what ministers are proposing to do is unlawful. Now, these two tectonic plates of the Constitution will grind up against each other again next month when the case goes to the Supreme Court. If the government win that, they're in the clear. But if they don't, it throws the triggering of Article 50 and Brexit itself, its timing and its manner, into real confusion.
All right, Clive, thank you. So what does all that mean for the government in practical terms? As we've been hearing, ministers say they're going to appeal today's decision. And that means going to the Supreme Court in early December. If they lose again, they'll have to go ahead with a vote in Parliament on a new act or law for MPs to approve. The problem for the government is that it might have to reveal some of its hand in negotiations, something ministers are set against. Well, let's catch up now with our political editor, Laura Kunsberg, who's at Westminster. Laura, realistically, is there any chance that MPs might vote against the government?
Well, George, this is a very big setback in what was already a fiendishly complicated and difficult situation for the government. Remember, Theresa May was adamant she just did not want to reveal very much of her hand, of how she wants to negotiate our exit from the European Union to MPs before she gets down to the nitty-gritty. And she certainly did not want to give MPs in the Commons a chance to try to tweak her plans before she was good and ready and before she'd started the whole process. Unless even more senior judges just down the road from from here overturn that verdict from today, that is what she is going to have to do. And that might unleash months of parliamentary shenanigans, with MPs trying their best to tweak the negotiations, to try to inflict damage on the government, and then the House of Lords quite possibly rejecting the plans maybe several times. And this is all, of course, hypothetical at the moment, but it's absolutely not impossible. Remember, Theresa May has a very small majority in the House of Commons of only 12. And one of the realities for her is that she is politically powerful, but not that powerful in Parliament. It is not the plan at the moment, but if the government gets stuck in months of parliamentary gridlock and a real tangle and mess over all of this, they may well reluctantly conclude that the only way out of all of this headache is to call an early general election. Now, I repeat, this is not the plan, this is not what Number 10 want to do at the moment, but given how difficult this is, given that Theresa May does not have her own personal mandate, it may become the blindingly obvious choice. This is a huge day, a difficult day, and we're only at the start of what we know is going to be one of the hardest jobs that any government has ever tried to pull off.
Laura, thank you.
So, a Brexit bombshell and a humiliating defeat for the government. Consternation tonight over the High Court's ruling that Theresa May needs Parliament's approval before triggering Article 50, beginning the process of taking Britain out of the EU. The government immediately lodged an appeal. There'll be a Supreme Court hearing next month, and Downing Street has been playing down any talk of a snap election. But could MPs, most of whom voted to remain, now frustrate Brexit altogether? From Westminster, our political editor Gary Gibbon reports.
The government said it was entitled to a free hand deciding when it formally declares Britain's leaving the EU. The High Court today said it wasn't. The investment manager, who was one of those who brought the case, said the government should accept defeat.
The judgment, I hope, when it's read by the government and they contemplate the full judgment, that they will make the wise decision of not appealing.
The government said it would do nothing of the sort.
We are appealing this to get on with delivering the best deal for Britain. That's the best deal for growth, the best deal for investment, the best deal for jobs. The people want us to get on with it, and that's what we intend to do.
The High Court said the government could not announce to the EU it was leaving the organisation without MPs' approval. That, it said, would be contrary both to the 1972 European Communities Act and to the fundamental constitutional principles of the sovereignty of Parliament. Government, the judgment said, does not have power under the Crown's prerogative, powers where government can act without Parliament's approval, to withdraw from the European Union. At the Supreme Court, an unprecedented 11 justices will look at the appeal. Their judgment's expected in January. If they back the High Court against the government, that means a bill in Parliament is needed. Some pro-Leave MPs think the courts have opened the way for some pro-Remain MPs to stall the formal notification of Britain leaving the EU, what's called Article 50.
Government has to do that to enact what the British people have decided. If Parliament gets between that and then says no, then they're again saying what the British people said. This is a constitutional crisis if that was allowed to happen.
There is no constitutional crisis. I have no belief that Ian wishes to undermine the rule of law. The rule of law is that we have an unwritten constitution, but the ground rules are very clear. And the ground rules on this, I think, are crystal clear, which is that what Parliament grants by statute, Parliament has to remove by statute.
Analysis suggests some 3/4 of English constituencies backed Brexit, some 3/4 of all MPs backed Remain. Some veteran MPs think their colleagues will be very wary of doing anything that risks looking like Parliament is taking on the people.
We do have to accept the outcome of the referendum, however disappointed we were. I think we would have a very different kind of problem if Parliament were to take that decision. I don't think that will happen. But I do think
that's the mood of MPs?
I don't think so.
One former MP and former Prime Minister said MPs should seize this moment to shape the Brexit deal.
And your advice to people still in Parliament is to push this to the limit, to use this choke
on Article 50 to shape the negotiating strategy, presumably, as far as you're concerned, to stay in the single market, to stay as close as possible to you?
Well, I want us to respect the result of the referendum, but the result of the referendum is to accept that people want to leave the European Union. But the manner in which we build a future relationship with the European Union must be the subject of debate in Parliament and decisions by people who have been elected representatives of the country.
Scotland, like Northern Ireland, voted to remain in the UK. Scotland's First Minister today said her government might wade in on the Supreme Court appeal.
We'll be looking at the judgment very carefully, and yes, we will actively consider whether or not there is a case for the Scottish Government to become participants in that case.
Theresa May at a London Awards dinner last night, just after hearing Boris Johnson say the government would make a titanic success of Brexit. The High Court judgment hasn't sunk Brexit, but it's complicated it, may yet end up to contributing to a delay or even changing its content, much to her annoyance.
Well, Gary joins me now from Westminster. Gary.
Well, Theresa May, at this point in the whole process, had about three central objectives: holding her negotiating cards close to her chest, making sure that MPs didn't have some kind of vote veto on the negotiations, and also delivering to European partners the Article 50 moment when she formally notifies them Britain is going at the date that she said she would, by the end of March. Now, all three of those are now under threat, because if the Supreme Court upholds the judgment of the High Court, there's a bill that has to go through the very complicated processes and oppositions of Parliament. Both peers and MPs could make that very sticky, and if things get sticky, all sorts of things can happen. In addition to delay and other things, you could even have the possibility of an early general election coming back onto the agenda. We are, remember, a very short way down this long march towards Brexit, and already things look extremely complicated.
Gary, thanks very much. Well, the judgment has really thrown everything into flux, as Gary's just been saying. So with me now is Gina Miller, the lead claimant in the High Court case, and the Conservative MP and Brexiteer Kwasi Kwarteng. Kwasi Kwarteng, the Leave campaign was all about parliamentary sovereignty, and that's what you've got. You must be delighted.
Well, I think that the circumstances of the case, the first thing I'd say is I think congratulations to Gina. She won her case. I think the government...
Because initially you said they were grandstanding.
I think they were grandstanding. And let's not kid ourselves. I don't think this is about parliamentary sovereignty. I think Gina, rightly or wrongly, was very upset about the referendum. Lots of people I know were very upset. And they are going to try and frustrate the process. The way to frustrate that process is to delay or simply obstruct the triggering of Article 50. We all know that. And this is what this is about.
Gina Miller, outside the High Court today, you said this is not about how anyone voted. Well, there are 17.4 million people who would beg to differ and will doubtless be saying this is exactly the sort of elitist intervention that enraged them in the first place.
Well, if anyone knows anything about me, I am definitely not elitist. I have worked very hard for everything I've got, and my principles, be it from when I was living in a one-bedroom flat to now, are exactly the same, which is I believe in the system of law. I believe we need a process, and it isn't about how you voted, because we've gone past that, and all the people who are saying that, all the politicians who are saying that, really need to get a new record. We are leaving. It is about how we're leaving. And if they believe that their jobs that they are paid to do is to debate in Parliament, why are they so afraid of doing that same job?
But Kwasi Kwarteng and many others say this is about frustrating the process and shaping Brexit the way that suits you.
No, I'm not a politician. That is up to them. What my case was about was the fact that the government were going to use this ancient, secretive, royal prerogative to trigger Article 50. And if they had done that, because we have an unwritten constitution, they would be setting a precedent that they could do that in future and use that royal prerogative to take away people's rights.
But the simple fact is that the only way to leave the EU is to trigger Article 50. That's the only way you can do it. The 17.4 million, a majority of people decided to leave the EU. So in order to effect that, in order to actually fulfill that mandate, you have to trigger Article 50. So any move to frustrate or delay the triggering of Article 50 is a move to frustrate and delay the outcome of the referendum.
You know, what are you afraid of? You know, it is your job to scrutinise these things. Why don't you want it to go through Parliament to be scrutinised with other issues?
And you heard from, I mean, Gordon Brown is no longer an MP, but Hilary Benn is an MP. He's a distinguished Labour MP. My own view is that it would that the House of Commons would be insane to try and overturn the referendum. You heard from Hilary Benn, you've heard from other Labour figures. They're not going to seek to do that. So I think this horse has bolted. I don't think we're going to stay in the EU, and I think the Prime Minister was quite right to say that Brexit means Brexit. We are leaving the EU.
But that's not what this case is about. It's more politics. This is
sure?
not about politics. If you look at Article 50, it very clearly says the member state has to trigger it along the lines of its constitutional requirements. This is about the constitutional requirements of how you trigger Article 50.
But this is about reshaping Brexit, isn't it? Ultimately, it will become about
that. Will be up to the politicians.
But why would you want to frustrate?
It is not frustrating.
But why would you want to delay the triggering of Article 50?
No, I want it to be done
I
want it to be done with legal certainty. Can you imagine if Article 50 was triggered and then a number of legal cases or challenges came up which said, but you didn't do it along the lines of your constitutional requirements, and that 2-year clock had started ticking, we would be in a worse place than we are now.
But you're not doing this to make us bomb-proof against further litigation. You're doing it because I understand that you were very disappointed with the result, and you feel that you want to frustrate.
And that's true, isn't it? You were disappointed.
I was disappointed.
Well,
I was a Remainer,
and
as were many millions of people.
Yeah, sure.
But this is not about that. You move on. This has got to be about how we leave. And everybody who starts arguing, politicians, about this is frustrating leaving, have really got to be more serious. This is about taking on your responsibility, which is to talk about how we leave, how we embrace this most momentous of occasions happening, rather than accusing people like me of frustrating the process.
It's a very simple argument. The only way you can leave the EU is by triggering Article 50.
And I'm not arguing against that.
Any attempt to delay that is seeking to stay within the EU, which is what the people voted against. So what was the point of having the referendum in the first place, if Parliament and judges are going to subvert
you're not arguing
the
my case.
verdict?
You're not arguing against me,
Gina,
because I'm not saying any of that.
Gina Miller, Kwasi Kwarteng, I'm afraid we're going to have to end it there, but thank you both for coming in. Well, that's the political reaction. Our business editor, Siobhan Kennedy, is in the city. Siobhan, how have the markets responded today?
Well, Jackie, to put it in context, we all knew that the pound has been hit hard since the referendum in June, hit particularly hard with all this talk of a hard Brexit, pulling out of the single market, and the pain that that would inflict on the British economy. Well, today, after the High Court decision, we saw an immediate spike in the value of the pound. At around 10:15 this morning, after the High Court decision was announced, the pound jumped from around 1.23 against the dollar to just shy of 1.25. A small, yes, but significant jump nonetheless. And why is that? Well, it's because investors took the High Court decision as a sign that we may now be less likely to get this hard Brexit, that the process will have to now be more collaborative, and that we may not pull out of the EU, the single market, in one fell swoop. And whether or not that turns out to be the case, sorry Jackie, whether that turns out to be the case, we simply don't know.
And it wasn't the only spike of the day, was it?
No, it wasn't, you're right. Let's bring up that graphic again. At around midday, after the Bank of England announced that it was dropping its plans to cut interest rates, we saw another spike. You can see it here, because it said the economy was faring much better than even it believed it would a month or two ago. Worth noting, though, Jackie, that they also gave a healthy dollop of pessimism about the inflation outlook and the outlook for growth in the years to come. So to summarise, Jackie, there was a surge for the pound today, yes, but to put that in perspective, that 1% gain that we saw on the day really only brings sterling back to levels seen at the beginning of October, and that is still some 16 or 17% off the level that we were at in June before the referendum.
Siobhan Kennedy, thanks very much. Well,
taking our leave of the EU was always going to be tricky. The question is, does today's unanimous High Court ruling that the Prime Minister doesn't have the power to trigger the official process make it a lot trickier? The Governor of the Bank of England has already weighed in to opine that the ruling adds to economic uncertainty. The government has appealed the High Court's decision, but it all might mean that the deadline for the end of March set by Theresa May will be busted. And technically, it could mean MPs blocking Brexit. There's also the possibility that the Remain nations and regions, Scotland, Northern Ireland and London, will use this decision to push for powers allowing them to negotiate directly with the European Union over parts of the Brexit settlement, a path advocated by the former Prime Minister Gordon Brown in a speech in London today. Our political editor Nicholas Watt has been looking at where the government and Brexit goes from here.
In those distant summer days, it had all seemed so simple. The people had spoken, and our shattered political class would follow their instructions.
Brexit means Brexit. The campaign was fought, the vote was held, turnout was high, and the public gave their verdict.
But now the counter-revolutionaries have struck back. One of the highest courts in the land has declared that the government cannot rely on ancient royal powers to trigger the process to take the UK out of the EU. The High Court said Parliament must give its approval, prompting an immediate announcement by the government that it would appeal to the Supreme Court.
Please join me in welcoming vote leaves.
Amid talk that the ruling could destabilise the government and eventually trigger an early general election, Leave campaigners made clear they were unamused.
I think the High Court has given a licence to this unholy alliance of a fund manager, Lib Dem members of the House of Lords like Paddy Ashdown, who I've been debating with today, and of course an unelected judiciary, to scupper what is the will of the British people and the biggest democratic mandate of my lifetime. And it's hugely uncertain what happens next, partly because the High Court have said that the government can't take this decision without the approval of Parliament, but they haven't said what Parliament must approve. Is it just a motion or is it legislation? They haven't said whether it has to be passed by the unelected Lords. And I think a lot of people in the wider country wanted to see Remainers and Leavers rowed in together and try and have some unity of purpose to get the best deal for Britain. And this makes that harder, not easier.
But a leading Remain supporter hailed the ruling, which will force the government to introduce a parliamentary bill if it is upheld by the Supreme Court.
There's nothing more empowered than a government going into negotiations with the negotiators on the other side realising they have the backing of Parliament. You know, it isn't for nothing that since the Middle Ages, as it was King Henry VIII said, we are never so high in our estate royal as in the time of Parliament. Because when Parliament gives the executive its support, the executive is strengthened. And the danger we've had at the moment is that the executive has been trying to find ways of avoiding Parliament, and that's a mistake.
Downing Street was officially relaxed today as it played down talk of a constitutional crisis. But there are dangers for the government if it loses that appeal to the Supreme Court. If the overwhelmingly pro-EU House of Lords votes against the bill, that could delay the start of the Brexit negotiations by a year. In the House of Commons, only a tiny handful of Tory MPs would contemplate voting against the bill. But Newsnight understands that some Tory MPs are prepared to table what are described as hundreds of amendments to the bill to force the government to negotiate a soft Brexit. One ex-cabinet minister who campaigned for the Leave side warned her colleagues to be careful.
It was a clear manifesto commitment on which the Conservatives were elected, that we would have a referendum, we would respect the results. More people voted to leave on the 23rd of June than have ever voted for anything else in the history of British democracy. Uncertainty is damaging economically, it's not good for businesses, it's not good for individuals. We need to get on with this.
Britain's most tireless pro-European, who voted for the 1972 Act of Parliament which took the UK into the EEC, agreed with the High Court that it is an historic measure that can only be overturned by Parliament.
I was a whip. I helped get the majority for it, but we had quite a job getting it through, as I remember. And we spent weeks on it, days and nights. Because I was a whip, I had to be silent in debate by convention, but I listened to hours and hours of it.
So, Ken, there's obviously going to be some sort of vote in Parliament on triggering of Article 50. Can I ask, how are you going to vote?
I will vote against it. I mean, for 50 years I've been arguing with strong convictions that it is in British interest to be a member of the European Union, and I shall stick to my guns. I'm not going to cast a hypocritical vote.
And is it your hope and expectation that as this process gets underway, it's possible that we might have a second referendum at the end of this?
I'm afraid I don't think that. Now, I'm more pessimistic than some of the more way out pro-Europeans. Now, I think the referendum will settle the fact that we're going to leave the European Union.
In true British style, this process will bump along. Perhaps in the end, there may be some sort of fudge that will allow those Brexit talks to begin on time, possibly with some conditions attached.
Nick Watt will be hearing again from Nick later. Well, let's talk now to Emily Thornberry, the Shadow Foreign Secretary, and the Conservative MP, Kwasi Kwarteng. Good evening to you both.
Hi.
Kwasi Kwarteng, I mean, this is what you wanted, British jurisdiction over British matters. This is what taking back control is all about.
Well, I think the main thing about it was the fact that people voted overwhelmingly in large numbers. It was a decisive majority in favour of leaving the EU. Now, the only way you can leave the EU is by triggering Article 50. So why on earth would you try and postpone that if you didn't want to frustrate the process, if you didn't actually want to stop the process of leaving the EU? Now, there's a lot of high-sounding, very elaborate arguments about parliamentary sovereignty, but let's face it, the reason why this is happening is because people are very upset with the result. You look aghast and shocked, but they're very upset with the result, and they're using legal means, and that's well within their right to do so, to try and frustrate the result.
You'd be suggesting then that the senior judges in the land are upset and aghast at the vote and not actually making a decision on the basis of law. Is there some kind of political animus?
Well, it wasn't the judges that brought the case. It was, if you remember,
it was the judges that ruled on it. They made the decision.
But if you remember, it was Gina Miller who brought in the case.
But actually, it doesn't matter who brought the case. The judges are independent.
And she said that she was very frustrated and very upset that she hadn't got what she wanted in the referendum.
So do you think the judges then were acting with some kind of political agenda or some kind of animus? Or were the judges being independent?
What the judges were doing was going against what the British people had voted for on June the 23rd.
Well, Emily Thornberry, you believe that Parliament has a key role, but if Parliament decides it doesn't like the terms or doesn't believe actually it should leave the EU, does it have the right to override the will of the people?
No, I think that Article 50 is going to happen. I think that Parliament in the end will vote for Article 50 to be triggered. But the really good thing about this judgment, which we didn't ask for, but if judges have to force them to do it, then let the judges force them, is that the government will need now to come to Parliament and actually give us some basic terms on which they are going to negotiate Brexit. Because, I mean, Kwame's right, the public wanted to leave the European Union, but there are many different ways in which it can be done. And the best thing for Theresa May to do when going into Europe is to say that she has the backing of the country. She can't just say she has it. She has to actually begin a conversation, a debate. She needs to be able to put down some basic ideas on the table.
So basically what you're saying is that even though the majority of parliamentarians would be for Remain, actually the sovereignty of Parliament is only OK up to a point because the majority of people in the country, 52%, voted to leave.
No. The point I'm making is this, is that I don't think that is right for the executive to say we will in secret negotiate on behalf of the British people. They need to be able to bring their basic plans to Parliament in order to debate it, because we do represent the countries and the nations of our country. I mean, that's the point.
But if you represent the nations of your country, then what do you say to negotiations by territory? So, for example, Northern Ireland, under the terms of this, might put in amendments, Scotland might, London might, to have different terms of negotiations. That's what the amendments are going to be like, aren't they?
I think it would be chaotic. I also feel that, we're the United Kingdom.
But do you reflect your constituents or not?
Of course we do. But
well, a lot of constituents in Northern Ireland and a lot of constituents in Scotland and London wanted to remain.
But the thing is, Kirsty, we have a national parliament. There's only one national parliament. They're devolved parliaments, but there's a national parliament and there's a national government for the United Kingdom.
But what we can't
and it's
have,
on that basis that we will seek to leave the EU.
But what we can't have is one particular faction of the Brexiteers saying we have a democratic mandate to leave the European Union in a certain way and we will ignore everyone else. A proper statesman-like thing to do is to try to act on behalf of the 100%. And that's the important thing.
So the Daily Mail tomorrow morning is calling these judges in this country enemies of the people. Do you agree with that?
That's a thing for the Daily Mail leader writers.
But do you agree with it?
I don't think they're enemies of the people. They took a view. I happen to disagree with the view, but that's what they
casting a slur on one of them for being gay.
No, I mean,
let's be clear now about the role of Parliament and the role of constituents.
Sure.
In Islington, your own constituency, 75% of those who voted to remain. But of course, in many Labour constituencies and other areas, the overwhelming vote was to leave. What is your principal responsibility?
My principal responsibility is to act on behalf of the country as a whole. 75% of my constituents voted to leave. The majority of Labour voters voted for us to remain. But we have to act on behalf of the whole country. In the end, we're Democrats. And the majority of people who voted in this wanted to leave. Now, the question is how to do it. And in that way, that's when Parliament swings in. And we do not allow the executive a free hand at this moment. And we should not. And particularly since they won't even tell us what their negotiating position is.
I think the widely accepted view on both sides of the House, in the Labour Party and the Conservative Party, is that Article 50 will be triggered and that we will leave the EU. There is a debate, as you can see, about the nature of the exit.
Yes.
But the idea that
which you presumably would welcome.
Which is always going to happen anyway.
No, it isn't, because you're not telling us on what basis you want to leave.
Article 50 would be triggered, people like yourselves will be arguing endlessly about the nature of the discussion.
Absolutely.
And the discussion will take 2 years. We don't know where that will end up.
The difference now, surely, is that there will be debate in Parliament if, of course, the Supreme Court
and we've already had
overturn
debate
this.
in Parliament.
No, we haven't. We've had us asking you questions and you not giving us any answers.
The debate presumably will be much more detailed about particular negotiations, which, of course, I understand, of course, the government doesn't want to show its hand, but that is the demand of Parliament.
But once Article 50 is triggered, there'll be 2 years of negotiations. There's no Parliament in the world that can decide what the nature of those negotiations will be. There's no Parliament that can prescribe what the course of the government will be in the 2-year process of the talks.
Thank you both very much.